Welcome everybody to the show here today. We have an important breaking news event that's going on that just happened yesterday in the Gerhardt Konig case. I'm not sure how many people are reporting on this, but a bombshell motion was filed yesterday by Konig's defense, and we're going to get into it. And I was tipped off of this by a source that I have in it that is close to the case over there and is keeping track of things for me and helping me out. So I really appreciate it that individual tipped me off to what's going on here. But we're going to get into it because this is massively important and it has huge implications for everything that's going on with this case. And we're going to get into all of it, okay? So the first thing I want to do, the easiest way to kind of bring you into speed is, first off, every member gets access to a case notebook. This case has the case notebook. Everything you're going to see, every visual you're going to see lives in that case notebook, along with every transcript, the full transcript of the trial, all of our coverage, everything. And you can go over and you can interact, ask questions, and I'm sure you have lots of questions about a complex legal motion like this. So this is a great thing to have, a great tool to have, and every member gets it. And if you go to our website, www.justiceisaprocess.com, find the Konig case, you can click and become a member. It'll take you to the YouTube membership page. Once you're a member, you can click the case notebook, and it will open it up for you. It'll take you to the member post where the link lives, and you can access the notebook that way and then bookmark the link. Anyways, with that being said, let's jump into, that's the first thing we want to do here, is I want to get into this. I want to get into the case notebook here, and I want to present to you the cinematic learning tool that we have here, which it's about 6 minutes long, but it's going to break down exactly what's going on, exactly what's happened here, and it's going to do so, I think, in an easy to understand way. And then from there, we're going to walk through and talk through this, so that we can kind of gain a better understanding for the audience here, because as justice watchers, that's what we're here to do, is to understand the process. And that's why my dad's old saying, justice is a process. I know it's not his saying, but it's what he loved to say about the justice process. It is a process, and that's why this is a process, because when things like this come up, when information like this gets out, the trial ends, there's a verdict, and then there's more to it. And there's always more to it. It's an ever-evolving process, and justice only occurs when the process that happens in relationship to a crime finishes fairly. That is justice. It's not an outcome. It's not guilty. It's not guilty. It's a fair process where all issues are raised, all rights are preserved, and all rights are administered. And then we get to whatever the outcome is at the end. That's justice. Anyways, with that said, let's jump in here to this little video overlay, that just summary that kind of summarizes what's going on, courtesy of Justice AI and Notebook LM. So here we go, guys. Let's check it out.
Behind the sweeping valleys of Oahu, a precise legal operation is currently underway inside the First Circuit Court of Hawaii. If successful, the motion filed by Dr. Gerhardt Konig's defense permanently caps his sentencing exposure and triggers immediate bail eligibility. Dr. Konig currently stands convicted of attempted EMED manslaughter. It is a Class A felony that carries a penalty of up to 20 years in prison. Defense attorney Thomas Otake engineered the DKT 419 motion like a logic circuit. It presents the court with 3 parallel arguments: misunderstood instructions, a legally non-existent offense, and external jury influence. The judge only needs to validate one of these 3 inputs to complete the circuit and trigger a cascading downgrade of the entire case. This motion targets the state's ability to refile Class A felony charges, aiming to remove the 20-year sentence from the board entirely. The first obstacle to any motion attacking a jury verdict is Hawaii Rule of Evidence 606. Rule 606 protects the integrity of deliberations by forbidding courts from probing a juror's subjective mental processes or emotional states. However, the official HRE 606 commentary provides an exception. It permits judicial inquiry into objective misconduct or external irregularities that were calculated to improperly influence the verdict. The defense relies on State v. Holbron to argue that their motion falls within this objective exception. Establishing the jury's actions as objective procedural failures allows the defense to bypass the general Rule 606 prohibition. Gate 1 identifies a deviation from the court's strict sequential directives. Judge Wong instructed the jury that they were required to unanimously find a specific intent to kill before they could consider EMED as a mitigation. The court's logic had a built-in fail-safe. If the jury found no intent to kill, they were legally required to skip EMED entirely and proceed to consider assault charges. After the verdict, the jury foreperson gave voluntary interviews to True Crime AZ and East Idaho News. She stated that the intent to kill was improbable based on the evidence. The defense then secured a sworn declaration from that foreperson under penalty of law. In it, she confirms, "I did not believe Dr. Konig had an intent to kill his wife during the incident on the Polypuka Trail." Because attempted EMED manslaughter requires a finding of intent to kill, the foreperson statement directly contradicts the verdict the jury returned. Under Hawaii law, specifically HRS Section 63556, a new trial is warranted if the verdict reflects a misunderstanding of the charge. Swearing under oath that the required intent did not exist while returning a verdict that requires that same intent constitutes a fatal objective error. Gate 2 maps Hawaii's violent conduct statutes into 3 buckets. Buckets 1 and 2, murder and EMED manslaughter, require specific intent to kill. Bucket 3, assault, covers reckless conduct, lacking intent. The dividing line is mens rea. Intent aims at a result. Recklessness disregards risk. This distinction created the legal paradox in State v. Stanley and State v. Loa. Attempted reckless manslaughter is not a crime under Hawaii law. The logic is that a defendant cannot specifically aim to achieve a result while simultaneously only disregarding the risk of that result. These two mental states are mutually exclusive. In public interviews, jurors described actions that could result in injury or had the capacity to kill. That is the vocabulary of the assault bucket. Using Bucket 3 reasoning to convict Konig of a Bucket 2 offense applies a legally non-existent theory. This mismatch makes the conviction a structural impossibility under the Stanley precedent, effectively opening Gate 2. Gate 3 addresses the risk of external influence entering the deliberation room in real time. The state disclosed a public comment posted during deliberations on the Law and Crime YouTube livestream. It read, "I've been texting with one of the jurors, and they're going for count 3 attempted manslaughter." The defense identified 3 markers of reliability in this post. The commenter accurately predicted the verdict, used the specific word count, which appeared in the foreperson's later interviews, and correctly identified EMED as the third option on a verdict form that was not yet public. Under the federal Remmer standard, private communications with deliberating jurors are presumptively prejudicial. This legal standard shifts the heavy burden back to the state to prove the contact did not harm the verdict. For the court, this is the path that requires the least interpretation. It relies on enforcing a structural rule against outside influence that has stood for 60 years. If the judge walks through any of the 3 gates, the EMED manslaughter conviction is vacated. This starts an automatic double jeopardy cascade. Step 1 is the implied acquittal. Under the Eli precedent, convicting on the lesser EMED charge functions as an acquittal of attempted murder. This stands regardless of the conviction itself, reaffirmed in McElrath v. Georgia. Attempted murder is permanently locked out. Step 2 involves the Whiting precedent. Hawaii law treats EMED strictly as a mitigation defense, not an independent offense. It can only be reached by charging attempted murder. Because that charge is constitutionally barred, the state loses the procedural vehicle for EMED. This cascade leaves the state without the legal mechanism to refile Class A felony charges. Following this cascade, the state's only refileable charge is attempted assault in the first degree. The difference is severe. Attempted murder carries a mandatory 20-year sentence. A Class B assault carries a maximum indeterminate sentence of 10 years. This structural downgrade removes the state's primary justification for denying bail, the flight risk associated with a 20-year sentence. With the penalty cut in half, the court has a legal basis to grant pretrial release. The DKT 419 motion demonstrates that procedural rigor can do more than fix a mistake. It can dismantle a prosecution's entire framework and legally force open a jail cell.
All right, so there you have it, guys. That's what we're dealing with here, and that is the crux of it. Now, on our website, I'm going to be putting a link to the actual motion filed by the defense, so you can get that as well if you want to read that. Also, there's going to be an article up on the website as well, explaining all of this in writing, as well as this video that we're doing right now in support of that. So, like I said, we're going to walk through this in greater detail, but I wanted you to see that visually, because it helps to visually, and you just saw my little helper back there. It helps to visually understand better how this works, and how this process. So we're going to walk through. I'm going to walk you through in greater detail, as I said, exactly how to understand this. But I want you to visually see it, because it's important to understand that there's a big that in order to understand how this turns out for the defense and why this could be a win. There's three possible ways, as we went through and we walked through this. There's three ways this could get overturned, but each and every one of them leads to the only charge Konig can face in the new trial is going to be attempted assault 1. And the reason being is because no life was lost. So as a result, and this is what the jury failed to understand, attempted red rum or attempted unaliving only applies to intent when there's intent. If there's recklessness, if there's an accident, if there's, all of that, which would be normally reckless manslaughter, if a life is lost, all of those are covered under the assault laws. So that was the part that the judge failed to make the jury understand. That's the reason why. Now, of course, Otake didn't actually want EMED to even be an option, and there's a reason why he didn't want it to be an option. The reason is because he didn't want there to be this lack of clarity. So it would allow him to say it's either attempted red rum or go down to the assaults and work your way down. The EMED caused confusion, and that's what he was trying to prevent. So let's walk through this, and I'll take you through as we're going through here, and we're going to walk through this little presentation here, and hopefully between the video and what we discuss here is going to really give you guys a better understanding of what's happening here, because this is going to be massive. This has massive implications, and for whether or not he gets sentenced in August, and whether or not if this does get reversed, whether or not this what charges he's facing in the retrial. And it also opens up the potential that if he ends up only facing attempted assault 1 charges, a strong case gets made that he should be released on bond. So let's jump in here and let's start going through this. So first thing to understand is, right now he's facing up to 20 years right now in August. And just to take you through what happened, on April 8th, he was convicted. He was convicted on attempted manslaughter based on extreme mental or emotional disturbance, otherwise known as EMED. Now, as I mentioned to you, the first thing you've got to understand is EMED, extreme emotional disturbance, is a mitigator. What's mitigator mean? What does that mean? Mitigation means it essentially lessens the punishment. Okay, it says, yeah, he did this, but there's a legally recognized reason why this should be looked at as less than if he just did it without this being present. The issue is that you must, in order for a mitigator to take effect, they had to find that he actually intended to kill his wife. That meaning when he went in that day, he was intending to do this, and then the EMED is when he was making that determination of intent, he had extreme mental or emotional disturbance. In this case, the jury's pointing towards the affair and all of that stuff, and that factored in, that this wasn't just a clean, I'm going to go kill somebody. He was very upset. He was emotional. He was mentally disturbed, but he wasn't mentally disturbed to the point where it's, temporary insanity. But it's just that that there was somewhat of a reasonable understanding of why someone could get that angry, but they're saying he still formulated the intent and said, I want her dead. And that's what that takes. Anything else, recklessness, or saying, hey, he gets into it and they get into a scuffle and he ends up doing something inherently dangerous, which could lead to a reckless, if she would have passed, if she would have died, that could have been potentially the foundation for reckless manslaughter. The problem is, there is no such thing as reckless manslaughter recognized under Hawaii law, because they say you can't have intent and you can't be reckless at the same time. Therefore, the reckless manslaughter is covered under the assault charges, or the attempted assault charges. That's where that lives. So this lays out the anomaly here was no one requested this. The judge added this in. The defense fought to keep it out. The state attacked it in closing, and it ended up ultimately being included as part of an option for the jury. The defense, for exactly the reason this is happening right now, the defense wanted it out of there because it was just going to cause problems and cause a potential misunderstanding of how to apply the law. That's exactly what happened. So the stakes here are, right now, he's facing up to 20 years. It is a probationable offense, although it's unlikely that he'll probably get probation, but it is a probationable offense. And, what's happened is on the 15th of, which is yesterday, on the 15th of May, the defense filed an 11-page motion alleging that there are fatal irregularities and outside influence in the jury's verdict. And that is important. The outside influence is something that we're going to talk about, because it's kind of, serendipitous almost, that the week that the Murdoch case gets returned or overturned for outside influence, this case, a motion lands in this case for outside influence. Unbelievable coincidence, I guess, in a way, but if that should tell you anything, it's something that judges, appellate courts take very serious. If any time outside influence can be shown, and just like in the Murdoch case, what you're going to see the evidence being in this case, it's pretty strong that outside influence entered that jury room. So 3 triggers right now. The motion gives Judge Wong 3 independent legal paths to invalidate the verdict. Grounds 1 is misunderstanding instructions. Grounds 2 is a legally non-existent offense, as in the reckless manslaughter does not exist or attempted manslaughter does not exist anywhere in the Hawaii Criminal Code. And ground 3, outside influence. The brilliance of the way Otake constructed this motion is, whatever door you walk through, double jeopardy applies and eliminates the top charge of attempted a second-degree unaliving. So basically any of those 3 grounds, and the third one is probably the one that's the most likely that the judge would walk through that door, because it doesn't involve having to invade the province of the jury's decision making. So it's likely grounds 3 would be one that the judge could say, well, grounds 1 and 2, I'm not going to grant. We're not even going to enter there. The jury, maybe they didn't understand things, but they were making a compromise. We're going to stay out of that. But if he finds on grounds 3, it's still going to cause, and we're going to go over that in greater detail, it's still going to cause us to not be able to go back and retry him on the top level offense. Now, the law governing navigating the strict boundaries of Hawaii's of rules of evidence is 606, HRE 606. And this is what's going to be at stake here for issues 1 and 2. And what it holds is it says that subjective mental processes, meaning, are off limits. And what does that mean? It means a judge cannot crack open deliberations to ask why a juror felt a certain way, or second guess their internal emotions. Meaning, we are not going to go put 12 jurors on the witness stand after a verdict and say, wait a minute, tell us what your thought process was. Why did you do this? We might think they got it wrong. But you're not going to cross-examine a juror on what exactly occurred in internal debates, internal thoughts, emotions, all of that stuff. Now, what is fair game under Rule of Evidence 606, HRE 606, is objective misconduct and outside influence. And the precedents for this is Holborn and Furatani. Has those two cases, which the defense cited, allows courts to examine objective irregularities, public statements, and improper external influence that could taint the deliberative process. And what they're saying is that's present in all three of those issues that they are raising. And these came up because of, well, one of them being because it was present in a live stream chat. The second thing that came up is the juror itself out speaking to the press on their own volition, discussing things that happened, discussing thought processes that occurred, and this was not done with inquiry from the judicial or from the judiciary. This was their own sharing, and what they shared indicates that there may have been that there was a misunderstanding of the law and a misapplication of the law, and therefore the defense is saying it's fair game. So ground one, let's take a look at what ground one says, right? It's ground one is essentially it ignored the decision tree. It ignored the instructions that the judge gave this jury. And what the judge told the jury, and I'm going to get out of the way of this second one here. What the judge told this jury is the following, is that first you have to determine, did the defendant intend to kill? Before you can, EMED is not considered as it is not a place that you compromise at, okay? Not when you're determining the issue of intent or not non-intent. Now, they could have dropped down to assault one to do that. That would have been perfectly fine. But you can't find someone guilty of attempted EMED manslaughter and then say, well, I didn't think they had intent to kill. It's impossible to do that. And the jurors failed to understand that. What the law says is did the defendant intend to kill? And and then if they did, was EMED present? In other words, was the intent to kill formed under extreme emotional disturbance or stress? And if it was, then you could find him guilty of EMED manslaughter. If you don't believe intent, which is exactly what that juror said to the press, as you're going to learn, then you must skip EMED and proceed to assault. And you go directly to assault, and you leave the attempted unaliving and attempted red rum, and you go directly to assault. Now, how do they know this happened? And this is important because the judge is going to say, okay, well, you can't just say that. You've got to know. Well, the way they know it is because these jurors, there were two jurors talking, juror number 3 and the foreperson. The foreperson said the intent to kill is improbable to us based on the evidence presented. She's speaking for everyone. Juror number 3 says, I don't know if he was trying to kill his wife. His conduct had the capacity to kill. Both of those are speaking to basically what would be considered to be and what would fall under the province of reckless manslaughter, but reckless manslaughter requires someone to have actually passed on. Since nobody passed on in this case, you look next towards the assault bucket. The assault bucket, yes, you could fit these squarely in the assault bucket and determining, okay, what level of attempted assault is he found guilty of? The jury didn't understand this. A conviction requiring intent to kill cannot stand when the foreperson swears they found no such intent. And she did that. And she didn't just leave it at a media statement. She actually swore to a sworn written statement that Otake is providing the court. Now, ground 2, a legal impossibility. So the attempt equals specific intent aiming at a specific result. Hawaii law does not recognize the offense of attempted reckless manslaughter. The mental states cancel that out. In State versus Stanley, in State versus Loa, which these have been in law in Hawaii for several decades now, they essentially assert that you cannot intentionally aim to cause death while merely disregarding risk. Meaning you can't formulate intent while being reckless. If you're saying somebody was reckless, in other words, and that's what this jury was saying, that they end up in a situation where they end up in a mutual combatant situation, and then he ends up escalating to a point where that's reckless, that was so reckless it could have caused death or grievous injury, and as a result, that's what happens. She gets grievously injured. She gets her head cut open. That's far different. That's far different than attempted second degree red rum. Okay, where which requires them to find that, yeah, he set out that day. Or they could even find that, which is what the state was asking, which was a place the jury could have gone and said, well, when he was making this plan, he was deciding to do this, he was emotionally and mentally disturbed because of the affair. But that's not what the jury said happened. They don't believe he went that day trying to kill her. They're saying, we don't believe that. What we do believe is that there's a fight that happens, they get into an argument, a scuffle occurs, and then he does something reckless, and it results in an injury. That is assault, okay? No two ways around it. That's assault. And what they did is they created a separate crime that doesn't exist, which is where grounds 2 kicks in. And here's the 3 buckets for you to visually see. So first of all, you have attempted red rum. What does that require? Mental state is intent to kill. Conduct, tried and failed, they didn't get it. Exposure, mandatory 20 years up to life in prison. Now, what they did find is attempted EMED. It requires the intent to kill, and then they find that it wasn't just that he intended to kill. There was emotional disturbance in that equation. They found him guilty of this. You get probation to 20 years is the mitigation for having the emotional disturbance. The problem is that the jurors are saying there was no intent to kill. So if you subtract the intent to kill, now you're at worst, assault in the first degree, which requires recklessness and a disregard for risk. The conduct is dangerous act causing serious injury, which is, again, once you get into that mental state, now you look at what the level of injury it caused, and there's an additional case, which is why, again, the whole defense, the whole way all of this would have been conducted in the next trial will be totally different. But the exposure is really key. 10 years maximum, and you can definitely get probation for an attempted assault in the first degree. So, convicting in bucket 2, reasoning in bucket 3. That's essentially what I've just been breaking out for you here. Is the mismatch. Attempted EMED, but the reality is, again, based on what the jury is saying, is capacity to kill, could result in injury, emotionally unstable, all of that falls under the reckless disregard for risk. This describes, and again, State v. Stanley states that a conviction cannot stand when the jury's reasoning reflects a non-existent offense. And that is a Hawaii case that's been around for years that the defense is relying upon, and that based on these juror statements, I don't think the judge can really ignore. They just can't. Now, grounds 3 becomes, in my opinion, this is the one that I think definitely can't be ignored. There was a live streamer, texter. They don't know who, the defense did not identify who this is or the identity of this individual. But there's a live stream texter who essentially texted or put into the live stream the following message. I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. This was on April 10th. The state disclosed an email from a viewer watching the trial live stream on YouTube. The chat message was posted while the jury was still actively deliberating. And the law that this defense is citing is Remmer v. United States, which states that private, and this is the same law that South Carolina just used to overturn the Murdoch case, that private communications with deliberating jurors are presumptively prejudicial. The burden shifts heavily to the government to prove harmlessness. It's why we are having a new Murdoch case. It's why we're going to have a new trial here. And we're going to get into just why this alone, if the judge finds with this alone, the state still loses the ability to charge or to go back and retry on the second degree red rum. But this is the important one to understand is Remmer does not allow private communications with deliberating jurors, and we presume that that's going to have a prejudicial effect. The state has a huge burden to show that it wasn't. And I think in this case, in this context, there's no way you're going to get away from saying that there wasn't some sort of prejudicial effect. If we have jurors reaching outside the jury room, there's just no way to separate that and say that that's an untainted jury deliberation. And we're going to get into the evidence of why it seems that this is very serious. So what the defense lays out in their motion is the indicia of reliability, which is the prediction, the terminology, and the position. So the prediction predicts attempted manslaughter, nailed the highly specific unexpected verdict before it was announced. The terminology uses count 3, and the foreperson, not saying the foreperson is the one that was communicating, but the foreperson is using the word counts in later interviews, though the official forms never use that specific word because it wasn't a count. There was a list, there was a menu of options, but they were not counts, okay? They were not counts, charged counts. And the position specifies count 3. Attempted EMED manslaughter was exactly the third option on the verdict form, which was not public at the time. And that verdict form was not public. So what this means is that whoever this person was that was texting, more likely than not, you could assume had information. Now, it was argued there. If you watch our coverage, okay, we covered it. We covered the jury because, in my opinion, the judge's the charge conference was highly important, and the judge's instructions was highly important, and we covered it. We covered exactly this. In fact, if you were a member, you would have gotten. We produced quite a bit of material on the concern that we had with how the jury was going to deal with this issue and whether or not this could cause problems. And it ultimately ended up causing problems. Now, the chain reaction. So here's what happens. First, and this is what's going to happen, and this is why the state is never going to get another shot at the attempted red rum if any of these reasons are found as a reason to give a new trial. First, the conviction is going to be vacated. If the judge grants the motion on any ground, okay, it resets it. Next is there's something called an implied acquittal, okay? And implied acquittal means it's the case that that's being used by the defense to argue this, but the case that essentially supports this is Mickelrath versus Georgia, and it stands that this will stand permanently. In other words, that under the that if you have a top offense, meaning if you have a lesser that's included and the jury is found with that, but you come back later and say, well, there's a problem with the verdict, there's a problem with the trial, double jeopardy applies. The state doesn't get the benefit of going back and retrying the top. The top is going forever, and what's tried is the lesser. And in this case, you're going to understand it's a little bit more complicated than just this, but the step 2 is the implied acquittal. So and that is that by finding him guilty of EMED, he was acquitted of the top charge of second-degree red rum. Now, the third thing is the Whiting blockade, okay? And what is Whiting? Whiting is a case that dealt with EMED, and it says that EMED is a mitigation, not a standalone charge. So because step 2, so essentially, you can't retry, okay? He was acquitted of the top charge of second-degree unaliving. The mitigating factor, in other words, in order to get EMED, you have to be charged with the original, but the jury found that the original doesn't stand. EMED is a EMED is a lesser, or is a mitigation, but it's still considered to be a lesser of regular second-degree red rum. As a result, you can't go back and charge him with second-degree red rum. So, and the Whiting blockade says that you can't charge with EMED manslaughter because it's not a standalone charge. So this irregularity between the statutes, the way the law is laid out, does not prevent and blockades the state from going back because they can't charge him with just standalone second degree. And the only way to get to EMED is by charging him second degree. So as a result, they're locked out because he was acquitted of standalone second degree, and thereby you can never ever again have the jury consider the issue of EMED. So they are blocked out because of this. Or it will take the appeals court to reinterpret how to deal with this situation. And better believe that the state's going to go ask that to happen. But based on how the law reads, they're saying that the lower court is going to have to find that essentially it's reversed and the state is blocked from ever trying again for for second degree unaliving, because the only way to get there is to go and charge him with second degree unaliving and then have the jury make a finding on EMED. They've already made a finding on EMED, but you can't charge him with EMED alone because you can't get there. There is no charge in the statute. And under due process laws of the 14th Amendment of the United States Constitution, I'm not sure what the amendment is in Hawaii off the top of my head, but in both of those situations, you can't create a new charge. The legislature can't go, you're not going to be subject to a charge that wasn't already present. That's unfair. So as a result, they are stuck at assault. So they're going to be stuck at assault in the first degree regardless. Now, if they find on all three of these, then they'll be stuck at it. There will be less to argue about because of 1 and 2. But if 3 is the only one the judge sides with, they're still not going to get the ability to go back and go for attempted red rum. They don't get another bite at that apple. Now, like I said, the real world consequence of this is Gerhardt Konig immediately goes from facing, at the beginning of this trial, he was facing life with a mandatory minimum of 20 years. His bail was denied because of the seriousness of those charges. Now he'll be facing a 10-year indeterminate max, meaning his max is 10 years. And the parole board in Hawaii decides when he gets released. The judge also can decide to give him probation as well. Of course, he's already served a bunch of time already waiting for trial, but bond would be highly, highly likely, and he would be able to have a GPS, passport surrender, etc. So it's very likely that if the judge finds this, he's going to grant bond, I believe, when that happens. So the architecture of this, if you can see this as and we'll show this in a bigger screen for you. You can see the masterfulness of what Otake has constructed, and that is you have grounds 1, grounds 2, grounds 3. Everything now turns on what Wong's going to do. But what's going to happen here is if any way that you grant relief on any of these grounds, it's going to potentially lead to no more than a Class B felony and a strong likelihood that Konig will be released on bond instead of what he was facing, which was up to potentially 20 years in prison. He was going to have a conviction on his record of a very serious charge, and he was going to be at the mercy of the parole board in Hawaii on when his release was going to happen. So again, this is a massive, massive, massive outcome for the defense. But now it'll be a matter of seeing what Judge Wong will do in this case. I believe that might be the end of. Yes, it is. So, all right. So that is, that's a walkthrough of where we are in this case. And like I said, it is a very interesting scenario, and it creates some very interesting legal questions. And these are the type of things that I know my dad would have told me. This is the stuff that, law professors and things like to be able to throw out there, and that would be debated for hours in law school on something like this EMED situation. How do you handle it, and what do you do, and where do you go from there? So let me show you one other graphic that I want to show you that I think cleanly demonstrates, and it's this here, the 3 paths to a new trial. And there they all are right there for you. But the end result of this is that Gerhardt Konig is going to get the opportunity, more likely than not, to be out on bond sometime in the near future if this motion goes through. And if this motion doesn't go through, he's going to have a great appeal, because the reality of the situation is what you've shown now in the Murdoch case. It took going to the state court of appeals in order to get relief. I think this case is a little bit more glaring and in your face, and I think it's going to result in a lower level overturnment. But we'll see what happens. We'll see where this goes. So let's go in. There's one other cool feature I want to show you. And give me a moment here.
Usually, when we talk about a jury verdict, there's this really profound expectation of finality.
Right, absolutely.
Like the doors of the deliberation room close, the jury debates in secret, and then the doors open, the gavel drops, and well, that's supposed to be it. We have an answer.
Yeah, the entire justice system is basically built around protecting that exact sense of finality. I mean, a verdict is designed to be the ultimate resolution to a conflict.
Exactly. But welcome to.
Oh, hey, welcome. What's up?
I'm here with my listeners, so I want to get your opinion on what do you think the likelihood is of success on this motion for the defense.
Ah, y- yeah, uh-huh.
All right, so I wanted to get your opinion on what do you think the likelihood of success is on this motion for the defense.
Oh, that is the absolute $1 million question. We are so glad you're jumping in with us.
It really is the question everyone is asking because the stakes for Dr. Koenig are incredibly high here.
Honestly, looking at the evidence and the way the law works in Hawaii, the defense's likelihood looks very strong.
I agree. And what's fascinating is how the defense attorney, Tom Otake, actually engineered this motion for a new trial.
Right, because he didn't just give the judge one reason to toss the verdict, he gave him three.
Exactly. And as we unpack these three doors today, you will see why it is so strategically brilliant.
Okay, let's unpack this first door because it involves those shocking post verdict interviews from the jurors themselves.
What's fascinating here is that the foreperson essentially admitted they didn't believe Koenig intended to kill his wife.
Here is where it gets really interesting because intent to kill is required for attempted manslaughter under the law.
If we connect this to the bigger picture, the jury basically described an assault but convicted him of manslaughter.
So, what does this all mean for the motion? Well,
Oh, go for it.
So, what I would like to know is, um, can you break down for the list
oh yeah, let's
break
hear it.
down for the can you break down for the listeners exactly why the manslaughter doesn't apply? In other words, why would recklessness apply under assault versus applying in the manslaughter category?
That is a brilliant question, and it really gets to the core of this legal puzzle.
Okay, let's unpack this because the distinction between these two is actually everything in this case.
What's fascinating here is that under Hawaii law, you simply cannot try to be reckless.
Right, because an attempt requires you to be aiming at a specific result, like a death.
Exactly, and recklessness is basically the opposite. It's just disregarding a risk without intending the outcome.
So those two mental states actually cancel each other out in the eyes of the law,
If we connect this to the bigger picture, the law calls it a legal impossibility.
which is why the assault charge is the proper bucket for reckless behavior that causes injury.
Assault is designed to cover that dangerous conduct where the intent to kill just isn't there.
So when the jurors said he wasn't trying to kill her, they moved into assault territory.
But by convicting him of attempted manslaughter, they essentially created a crime that doesn't exist.
This all means the motion has huge legs because the jury misunderstood those core instructions.
This raises an important
Oh, yeah. Uh huh.
Then, if the whole thing was flawed, why does the state get penalized, and why can't they just try the case all over again with a new jury and better instructions?
Oh, that is such a sharp point. It feels totally counterintuitive, right?
It really does, but it all comes back to a heavyweight legal concept called double jeopardy.
Okay, let's unpack this because even if the verdict is a mess, that acquittal is permanent.
Exactly. When the jury picked a lesser charge, they effectively said he's not guilty of murder.
Here's where it gets really interesting. Once that not guilty happens, the Constitution locks it in.
If we connect this to the bigger picture, the state doesn't get a do over on acquitted charges.
Even if the jury was confused, a landmark case called McElrath says an acquittal stands forever.
This means if a new trial is granted, the state is stuck with only the lesser charges.
So the state isn't being penalized.
Oh, yeah,
Okay,
uh-huh.
so we have a question for you. So, if the idea is that the EMED is a mitigation factor, then why would it not be considered that he was convicted of second degree, and that it's a mitigation factor, not an actual acquittal of the top charge? It's a mitigation of the top charge.
That is a really astute way to look at how the law functions here.
Yeah, you are basically describing exactly how the mechanics of EMED work in a trial.
What's fascinating here is that EMED is technically an affirmative mitigating defense, not a complete one.
Okay, let's unpack this, because it isn't meant to get someone a not guilty verdict.
Exactly. It doesn't say the defendant didn't do it or didn't mean to do it.
It actually acknowledges the intent to kill, but says there is a reason for it.
If we connect this to the bigger picture, it acts like a legal bridge.
It bridges the gap between a cold-blooded murder and a situation of extreme emotional pressure.
In Hawaii law, specifically the Adviento case, they call it an escape valve for the charge.
So when the jury finds that EMED exists, the law forces the charge to drop.
It literally reduces the offense from murder down to manslaughter because of that emotional state.
So while it's a mitigation, the final label on the conviction has to be manslaughter.
This raises an important question because the jury can't just pick murder and add a note.
They have to follow the specific path the law provides through those jury instructions.
This is why the state is in such a tough spot with double jeopardy now.
Because even if they used EMED to drop the charge, the murder acquittal is now permanent.
It's about preventing the government from using its massive resources to just keep trying.
Which brings us back to that second door for a new trial, that potential outside influence.
What's fascinating here is that a juror might have been influenced by a live stream.
There are allegations that a commenter on a stream knew details about the secret verdict form.
If someone was watching the show while deliberating, that completely compromises the whole judicial process.
It makes you wonder if a jury can truly stay isolated in our digital age.
This really shows why this specific case is such a strategic minefield for the prosecution.
We really appreciate you jumping in with those great questions. It makes the show so much better.
Thanks for joining us for this deep dive, and we will see you on the next episode.
See you next time.
So there you see what you can do. And if you are a Justice Watcher member, you get access. You can go in, and I have to create it, which I do. I will create the audio debates or whatnot, deep dives, and all you can go in and you see the little hand sign like you saw me clicking. You click the hand sign and it lets you interact, and you can ask questions. You can debate. You could see some of there are little quirks there that cause problems, but you could see how it worked. But anyways, ultimately, the key here to understanding all of this, as I was laying it out to you, is, what you heard explained there, is that, again, the real quirk with the law that's going to be at play here in this, and it will only really trigger if reason 3 is the reason why the jury why the conviction doesn't stand. In other words, if they reverse based on inappropriate, based on the live stream question that the jury was in contact with someone outside the deliberation room, then it leads to the idea that you're reversing, right? And then they're going to say, well, now the state is hamstrung and can't retry on the second degree on an issue that really was not even about whether or not the way they came about their verdict was correct. It's that they convicted him of something that doesn't exist in the law unless you get back to what they acquitted him of. And what they acquitted him of was second degree. And Hawaii law has held so far, unless this is the case that reverses that is a recognized acquittal. And McElrath says that acquittal of second degree red rum stands, period. And since they don't have a law, since they don't have a way to get to the law that he was convicted under, all right, if the judge finds that was okay and that the jury, they're not going to, that he's not going to weigh in on whether or not the jury's way of getting there was correct, even though there's statements and sworn statements after the fact that states that they did not believe intent existed. But if the judge doesn't touch that, that's going to be a point where, yes, I think the state will absolutely take that and go back and appeal that before it ever gets back to trial again. But importantly, I believe Gerhardt Konig has a very, very, very strong possibility that he will be getting out on bond, and that's huge for him because he'll be out of jail, where he's been sitting now for over a year since this event occurred. So anyways, guys, that's what's going on in this case. Huge stuff, huge implications. These are the things we like to follow. These are the things we like to bring to you. I want you to weigh in the comments on what you think about this. What do you think? Do you think he deserves a new trial? Do you think this is fair? I know there was a lot of you out there that felt he got what he deserved, or that you were hoping for something more. I know this is going to really, some of you out there are going to be very disappointed to think Again, this is where people get the idea of a technicality, and this is kind of the ultimate of a technicality because, yes, if the judge finds that the jury was tampered with and they go back and they can't try him of the higher charge because of the jury tampering, and the judge doesn't find that he believes the jury did anything wrong in the way they came to the verdict, it's the same outcome for the state. They lose the ability to try him on the top charge. And, is that justice? Is it, or is it not? You guys tell me in the comments. But it's important, though, that this is done right, that justice isn't interfered with by outside influences coming into the jury room. And it's important that a jury is able to understand the laws that they're supposed to be applying. And to me, this comes down to something that has always stood out to me, which is that you have regular citizens without legal training. Remember, if you're to become a lawyer, you got to get your high school diploma. You got to go get your undergraduate degree in college, and then you got to go to law school. You got to get 3 degrees to become a lawyer, right? Yet, and those are the people that are going to be arguing to everyday individuals who have no degrees. Some of them might not have anything past the high school. There's no requirement beyond citizenship and over the age of 18 to serve on a jury. Now, of course, attorneys and things can ask questions and determine what the educational background of these people are and all of that stuff. And they can try to ferret out the people that they don't think are going to be the right ones to consider the evidence. But at the end of the day, these people don't have specific legal training, and it's important that the law deal with that situation, especially when you have complicated legal matters. And that is a scenario here where the defense was bringing this up, was concerned about it, was worried about it, even went as far as to try to get rid of the EMED because they didn't want there to be confusion around this issue. And yet, here we are. There was confusion. They didn't understand how to apply it. They couldn't separate the two, and they convicted on a theory of a case that doesn't have any legal support anywhere in Hawaii law. This is the stuff, man. This is the stuff that I like to see and like to report on. So we will be covering this. We will be watching. We will be in the courtroom when this gets back and gets argued before Judge Wong. Until then, weigh in with me in the comments. Let me know what you think. And we may even do a live here. I haven't done a live in a very long time where it's just a live on just talking with you. This might be the one. And we can also talk about Murdoch, which predated Justice of the Process's existence in covering cases. But I was actually watching it with my dad very closely when it was happening originally for the first trial. And began kind of the sequential march to becoming what we are today. So anyways, guys, I also want to take the moment to thank each and every one of you subscribers out there that helped us get to, we're now over 105,000 subscribers, but we hit our 100,000 milestone, and we got our silver play button, as my young son reminds me. He was very impressed with that. And likes that, but the silver play button, and that is an amazing honor, and it's an honor to have each and every one of you hitting that subscribe button. We also temporarily hit 50 members. I think we're down to 49 now. So each and every one of you that's a member of the channel, I appreciate you. I thank you. I appreciate your support. It's what keeps the lights on. It's what keeps us going. It's what keeps us being able to operate. Because like I said, the ad revenues and things of that nature, I think there's a misconception of what that brings in, but it's not what this is about. What we're about right now is watching and keeping something alive that my dad was doing for his entire life and entire existence, and that was helping people understand the justice system so that when they become involved, they can better understand what their rights are and what they need to ask of their attorneys and of everyone else that's going to help them and guide them through their journey through the criminal justice system. Because truly, justice is a process. It's not an outcome. And we got to remember that. In this case, right here is a reminder of that very fact. So guys, until we talk again, let justice prevail, and I will talk to you soon.
Small town lawyer with a heavyweight heart, stood between the system tore apart. Murderers and innocents all sat in the same chair. He said, I don't judge them, I just make sure that it's fair. They told him, sit down. He stood right back up, said the Constitution ain't a maybe, that's enough. Due process warrior, he never backed down, fought for every single soul in every single town. Rich man, poor man, guilty or not, he said fair is fair and that's all that I got. Due process warrior, yeah, he was a due process warrior. Feds came knocking, said betray your client's trust. He said attorney-client privilege isn't up for us to bust. They took his license, threw him in a cell. 7 months in federal, but they couldn't break the spell. They told him stop fighting, he fought even harder. Coffee shop and paperwork, he never lost his armor. Due process warrior, he never backed down, fought for every single soul in every single town. Rich man, poor man, guilty or not, he said fair is fair and that's all that I got. Due process warrior, yeah, he was a due process warrior. They said he was dangerous for teaching people rights, convicted him for caring, but he never lost the fight. From the courtroom to the coffee shop, the mission stayed the same. Every person gets a process and we're carrying his name. Due process warrior, we're never backing down, fighting for every single soul in every single town. Rich man, poor man, guilty or not, he said fair is fair and that